Good morning, everybody. My name is Kevin Ring. I'm president of FAM. This is the first of two Facebook Lives we're going to do today. The first one is going to cover federal compassionate release. We'll do another one this afternoon that is going to talk about more general issues dealing with state and federal advocacy that is not compassionate release. We know we've got a lot of questions to cover. I just want to say at the outset that FAM has been working on compassionate release for a long time at the federal level. We were able to make changes in the First Step Act so that people who were eligible would be able to get to federal court if their petitions were denied or they didn't get an answer in a timely fashion. When this crisis occurred with coronavirus, we knew that emergency action needed to be taken. And we fear that the political branches, that's Congress and the executive branch, the White House, have talked about doing certain things, but hadn't done them. And so what we wanted to do is, knowing that when people apply for compassionate release, that the Bureau of Prisons has 30 days to respond, that we wanted to get the clock running. And so that as many people that were vulnerable in our federal prisons had a chance to get before a judge, and also had a chance to get before a judge with a capable attorney. And so while we have had for a while this clearinghouse on compassionate release with our partners at NACDL and the Washington Lawyers Committee, we wanted to ramp that up in a very quick way so that we could help as many people as possible in this crisis. I want to say a couple things at the outset. One is that I know people are very anxious and that this is a very stressful time for you and your loved ones, and we feel that and we share that. That's why we're doing this effort. But we want to make sure that you know that this is not a foolproof strategy. This is not the best way to go about this. It's just we thought it was the only alternative that we had to get people before judges in a way that might get them out if Congress and the president don't act. The president, as people know, said he was going to look at doing something for elderly and sick people. We haven't seen any executive action since then, except that the Attorney General then announced plans to expand home confinement. Our view is that that announcement that the Attorney General made didn't expand his authority at all, but actually put some limits on it. And so we're not sure whether that's going to actually result in that many people getting out. Having said that, we encourage you to look at the material we've presented that distinguishes between compassionate release, home confinement, and clemency, because people are asking us questions that make us think that three are being confused. Compassionate release is the one we're working on. That's the one that allows vulnerable people to get before a judge and allows the judge to make a determination about whether they should be released early. Home confinement is something that BOP determines. Now, there's some disagreement about whether the BOP is seeking people out to send to home confinement, or whether your loved one who's inside needs to ask his or her counselor or unit manager to consider them for home confinement. Different institutions have been doing this different ways, but that is outside of anything that we can help with. All we can do is recommend that you seek home confinement as soon as possible as well for your loved one. And finally, there's clemency. In the material we presented, and you can go to our page, FAM's homepage, and there's a COVID resource page. You know, applying for clemency in this situation, it's a long process, so it may not work. But we encourage you to take the steps on our COVID page to notify the president, your lawmakers, that you want action. Because if the president is going to grant mass clemency, that may be helpful to a certain class of people. We don't know who would be covered by that. So all we're talking about today and all we're trying to work on in this environment right now is federal compassionate release. If you have questions about state compassionate release or state issues, come join us at 2:00. But for now, I want to introduce to you Mary Price, our general counsel, and Juliana, our staff attorney, who are really taking the laboring oar on taking the requests. We have received several hundred requests from inside the federal prisons. And we've received more coming directly from impacted families. We're trying to process as quickly as we can. I just want to say this. I don't want to diminish expectations, but this is an emergency action that we do not know how this will go. Normally, in last year, there were just a little over 100 compassionate release grants made. That's not that many, but that was more than that's been done. We do not know if the courts will respond to these. We're seeing some good evidence that they are. Some courts recently have been granting compassionate release and citing COVID as a reason. We don't know if that's going to continue. But we're going to do everything we can in our power to get as many applicants in the hands of good attorneys to file these motions. And so with that, I want to kick it over to Mary to give you a little bit more about the overview of the program and what we're trying to achieve.
Thanks so much, Kevin, and welcome everybody to this this Facebook Live. We're delighted to have you. We are as concerned as you are about the situation in prisons and with your loved ones, and we realized that we had to do something within our power to try and bring the attention of individuals who are incarcerated and perhaps vulnerable to this virus to the attention of the courts if we possibly could. And Kevin's absolutely right. The compassionate release is an imperfect tool for this. There is probably no perfect tool, but it is the tool that we have to work with at the federal level. Compassionate release has rather rigid categories about who may or may not be eligible for a reduction in sentence. Compassionate release has ridiculous timelines. Kevin mentioned the 30 days. The warden has a period of 30 days from the moment the individual in prison asks the warden to consider them for compassionate release to even answer their request. And that 30 days also apparently limits the court. The court cannot act on a compassionate release motion, at least by the rules as they are currently written, until day 31. And even then, if the warden has said no to your loved one or to the prisoner, there may be an even longer to wait. So it's a super cumbersome system. And what we wanted to do was nonetheless to build up an army of lawyers, to find out who needed help, and to try and break down some of those structural barriers to compassionate release. Because we believe, as we believed when the First Step Act was being considered, when we talked about trying to get compassionate release power into the hands of prisoners so that they could ask for requests, is if judges could consider these motions, judges would be able to grant them. And today we are beginning to see the fruits of that. As Kevin pointed out in the first year of compassionate release, many more motions were granted by the courts. And we're beginning to see compassionate release motions that are responsive to the COVID-19 crisis. And the lawyers that are working on this issue right now are working to break down some of those barriers with respect to timeframes and what's called exhaustion. You may have heard about exhaustion. All of those things. We are working with some of the smartest lawyers we know to come up with creative arguments, sample briefs. We have recruited over 200 lawyers so far, and they are chomping at the bit to help. And as Juliana will tell you, we've heard from many of you and from people who are incarcerated about about their wish to be considered by the courts for compassionate release. One of the things when we set up, also to say briefly, when we set up the clearinghouse over a year ago now, we did so because we believe that a person who is represented by a trained lawyer is in a much better position than a prisoner who seeks relief pro se. We can't guarantee good outcomes. We don't know if this is going to work, but we also believe that people will have their best shot if they are represented by attorneys who are trained and equipped to do this work. So that's our job. We're working to raise an army to equip them to support your loved ones. That's all I have for right now, unless there's something else, Kevin or Juliana, that I've missed.
No, I was just.
And Juliana, if you want to talk about the intake process, sorry.
Kevin, were you adding something?
No, I was just going to say, why don't you talk about what we're receiving right now, how we're handling those, and maybe even some of what we've seen in recent court decisions that give us a little hope that this is a worthwhile path.
Yeah, so we get intake from multiple venues. We get intake from people writing us from inside prison via core links. I want to add at that point that we can't get physical mail right now because we're all under shelter in place, and so it's important to know that the best way to reach us is by email or phone. Prior to the shelter in place, we were also getting requests from mail. We get requests from Facebook, we get requests from our website, we get requests via email. We have a new survey on our website that I'm sure someone will link to in the comments for loved ones or concerned family to fill out to begin that intake process. Since we launched the survey yesterday, we've had over 125 submissions. We've had hundreds of submissions from people inside prison. We've had even more via other phone, Facebook, etc. If you haven't filled out the survey, that's the best place to start because it helps us keep the information all in one place. We are not able, as you can see, we are a small legal team. We are not able to respond individually to every single survey, but we are reading every single one and we're putting them in our intake system. After we collect all of the information that we need, it goes into our larger database where we work to match as many cases as possible with attorneys. We want to make sure those attorneys are well trained to do the specific area of law. So Marian and her team have been putting together a training that is now or shortly will be live for those attorneys. These kind of projects normally take much longer to get off the ground, and we're proud about how quickly we have done so. And we can now begin to match people with attorneys. People who've been matched will then hear from their legal team. We have seen requests from facilities across the United States and from family members across the United States and from Puerto Rico and from Hawaii. It's been really exciting to see the word getting out. I want to emphasize that this is an individual and cumbersome process that if we made the rules, it would be a different process altogether. But we think this is an emergency and we're using the tools that we have before us. As for recent court decisions, we've seen, as Kevin mentioned, we've been running this clearinghouse for a while. And so we've had some cases that were already beginning, that were already in the system. We saw 3 release orders on Friday and we've seen at least 3 come through this week where judges are taking note of the urgency of COVID and are refusing to buy into the BOP's assertion that everything is fine. And so that gives us hope that judges can understand that this is an extraordinary and compelling circumstance for people who are immunocompromised or elderly or fit the CDC guidelines to be considered for compassionate release.
Okay, I want to jump as quickly as we can into the questions you all have. That's what this is for. And I've already been sent a couple. One thing people are asking about is what the CARES Act did in relation to compassionate release. And the answer, as far as I understand, is nothing. The CARES Act just triggered if the Attorney General decides that the functions of the BOP are materially altered by this crisis, he has the authority to grant more home confinement to people. As you know, right now, home confinement is limited to 6 months or 10% of your sentence, whichever is less. Under the CARES Act, he has the authority to give people more home confinement. As far as I know, he has not invoked that authority yet to do that, but that does not affect compassionate release. So these are two separate things. I understand the confusion, but we want to ward against that. Another question that has come up, and I'm going to ask Mary and Juliana to address this. What if the warden doesn't respond within 30 days? Or what if the institutions are not accepting petitions? What should somebody do?
So if the warden doesn't respond within 30 days, the person who made the application is able to go to court by operation of the statute. So the statute says the court can regain what's called jurisdiction over the individual's case on day 31. So that is pretty straightforward, I think, and we do know of lawyers and individuals who are filing on the 31st day, and sometimes now with COVID-19 even before that. In the case, we want to hear, I think, if you're having the experience, if your loved one's having the experience of not being responded to or not being able to submit a compassionate release request to the warden, because that's the thing that begins this entire process, right? It opens the door for the legal process. If the warden is refusing to hear about that, I want to hear from you about that, because we think that that is wrong, it's against the law, and we're going to challenge that. Now, what I would encourage people to do whose requests have been refused would be to document that carefully, write it down, say, this is the day, this is what I tried to do, this is the day I tried to submit our request, and we're going to take that, we're going to understand that as day one. and we'll start the 30-day count after that. If a lawyer then takes that case, we're going to say he tried and it was futile. There's a futility argument in the law. And I think that we'll have lawyers working on addressing that. But we really do want to hear from you if you're not able to, if your loved one is not able to apply.
I just want to follow up. We already have heard from a couple institutions that people have been told that their counselor or their case manager is not taking them, and we've heard about that. So we're grateful for that. But yes, the other thing I was going to mention is, in that case, the family member, Mary, also should request it, right? If the counselor won't take
yes, of course,
inside prison, the family member could send a letter to the prison as well. Yes.
Yes, and definitely keep a copy of the letter that you send, make sure it's dated, keep copies of everything. And the other thing we'll try and do is, when we hear about those institutions, we're collecting that information right now, we're going to be bothering the Bureau of Prisons about this. This is inappropriate. People have to be able to ask for compassionate release. They have to be able to communicate with their lawyers. They have to be able to communicate with you. These are all issues that are coming up, and we'll raise those with the Bureau of Prisons.
Mary, a question that's come up a lot is whether a loved one can submit a request on behalf of someone in prison to the warden via email if they can't reach the post office.
I don't see why not. Certainly that's a request that's made. There's an email address called the executive assistant. So if you go to the website for the institution where your loved one is incarcerated, there's an email address for the executive assistant. You can send an email letter requesting compassionate release to the warden via that email address. And you should, again, keep a copy of everything. Your request should include two things. Number one, what are the grounds that your loved one is requesting compassionate release on? And number two, what's their release plan? Where will they live and how will they be supported? And whether, if they need medical care, how that will be provided. So those kinds of things don't have to be entirely fleshed out, but you definitely need to be able to indicate that you have a release plan. Those are the two elements of a compassionate release request.
Juliana, for people who have submitted questionnaires, how are you dealing with incomplete ones where we don't have answers? How are we trying to make sense of that? Because I know sometimes people don't answer all the questions. I guess, one, I'll put a plug in for answering all the questions. If you are the loved one on the outside, please answer as much as you can, because we need that information to give the lawyer the best shot they have in court. But what are we doing in those circumstances?
Thanks for the question. Also, we're using the words survey and questionnaire interchangeably. They are the same thing. It is the link on our website. And I want to stress that's not the same as making the request to the warden. When you fill the thing out on our website, that goes to me. Mm-hmm. And when you fill onto my team, I don't work with, we advocate on behalf of FAM members to the BOP, but that we don't start that process. So there are two different things that need to happen. We want to hear from you as soon as you make that request, or even if you're not able to do so that we can start the intake process. As we input all of the questionnaires, if they are incomplete, we will reach back out. If it's a situation that we think we can help. And some people have heard from me already, and other people will hear from me. Many of the fields on the questionnaire are not mandatory. You can submit without filling them out because people may not have all the information, and we want to start the process as quickly as possible. But like Kevin said, we really do need to know as much information as you have, especially about why the underlying conditions your loved one may have, or why you're asking for compassionate release.
Somebody asked about people who have submitted their application to the warden, but now they're under the 14-day quarantine. Would it be unreasonable to expect that there may be an unannounced policy to waive the process under the present circumstances? I guess, Mary, this goes a little bit to your exhaustion issue in my head, which is, I don't think there is a 30-day rule in the statute, but I don't think attorneys are waiting to submit these. I think they're going to get them in as fast as they can, making the argument that this is an unprecedented crisis, that the lockdown and other things are going to prevent the normal communication. So I think we're moving as fast as we can, 30 days, regardless of that. Is that true? It's
true. 30 days is a lifetime right now, right? And so in some cases, a person may be particularly vulnerable, or there are deep concerns, and we are seeing lawyers filing before the 30 days. Now, it may not be the case that the judge will accept or be able to rule on that motion. It depends on, court by court, how they're going to handle these. But probably one of the most creative things we saw even before this crisis was an attorney who both made the request to the warden on behalf of the prisoner on day one, and on that very same day filed a motion in court and asked the court to just put it aside for 30 days. And the judge did and ruled on, I think, on day 31. So all of these things are being pushed and tested right now. Whether or not you're going to need a wait of 30 days or not is all up in the air. And all of these arguments are being tried already by judges or by lawyers who are representing people who are already in the pipeline. And we'll be learning from those and teaching our lawyers some of those strategies as we go forward. We just don't know yet. It's a very fluid situation right now, so we don't know yet how the courts are going to rule, and they're not all going to be the same, obviously. But we're trying everything we can in the toolbox, and we're trying to build the toolbox, right? I mean, there's new arguments every day, new strategies every day, new approaches. We're gathering all those. We're making sure that our lawyers will be trained in those and have those at their fingertips when they're assigned a case that of the people that Juliana and her team are processing.
We're getting a lot of good questions in, so I'm going to try to get to these and we'll get through them as quickly as possible. Mary, what should a release plan include? A home to go to and anything else? What is a good home?
If your loved one had insurance before they were incarcerated and can regain their insurance when they get back in the community, that's useful to talk about. If they're eligible for Medicare or Medicaid, you can begin the process of looking into that, or SSI and Social Security. If your loved one was a veteran and is eligible for veterans benefits. So you want to sort of explore all of the opportunities for providing financial and medical support that are at your fingertips. We're going to try, we haven't started this yet because we're still trying to build the front end of this, but we'll begin to work on developing more resources for our families and the prisoners and loved ones for the back end. So we'll try and bring on support from social workers to help you do a better job of release planning. Again, I would not worry about it. It doesn't have to be totally cooked when you make the request on behalf of your loved one, but those are the kinds of things you could start to think about. And we'll have resources posted on the Compassionate Release Clearinghouse website, which will hopefully be useful to you as well.
Some quicker, shorter ones, I think. What if there's no contact with inmates to tell them how to apply? Can a family member apply for them? Yes.
Yes.
Use the questionnaire that we have on our webpage to do that.
No, wait, can I add something?
Yes.
A family member can apply to the warden.
Right.
Which is not via our questionnaire. Those are two different.
Yes.
We want the family member, if the person is on lockdown and has no contact, a family member can take action, and we want them to do two separate actions. We want them to fill out the questionnaire so we know what's going on and for our information, and we want them to make the request to the warden. Ultimately, the attorney, if we are able to find an attorney, which we can't do in all cases, that attorney will need to schedule a legal call to make contact, because a lawyer has to talk to their client at some point, but that'll come later. Sorry,
so somebody else asked, I submitted the questionnaire. Should I email the warden executive assistant as well? So the answer is yes. You do have to do both things, because contacting the institution is what gets the clock running. Contacting us is what allows us to find you a lawyer.
Don't send the question. Oh, sorry.
I said in some cases. We cannot promise a lawyer in all cases, but we are not the BOP.
Yes. Okay.
Don't send the questionnaire to the lawyer. Don't send the questionnaire to the lawyer. Can you hear me?
Yes.
Okay.
No.
Send the questionnaire to us. I send the questionnaire to the
BOP.
The BOP.
Yeah.
Right, to the BOP. Yeah. Sorry.
It's okay. I filled the 2 questionnaires and send them to you guys on Monday. When can I expect an answer?
We have been besieged with requests, which is an excellent thing. I'm really glad people know about this. We're trying to do the attorney matching as quickly as possible. If you need an update, you can reach out to us and we can give you one.
Let me just say this. If you filled out the online questionnaire, assume we have the information, because that's auto-populating into a database, so we have it. So the next contact you should get is, if we found you an attorney that can handle the case, they'll reach out to you. If I understand how anxious this is. And every day that goes by, there's another death in the prisons, and it's amping up the anxiety. And we totally appreciate that. If you at any point feel that you cannot wait any longer and you are going to proceed with a private attorney, by all means do that. I don't want to discourage anything. I don't want to raise expectations higher than they can be. We're doing everything we can with the team we have and the volunteers we have to get you competent legal counsel to give you the best case. But I totally understand the anxiety and the desperation that may lead people to just say, I'm going to go it alone. If you do, let us know, but also know that we're working as fast as we can. We sent the letter into 40,000 people in federal prison just last Monday night. So in that short period, we have recruited over 200 attorneys, taped the training to make sure that they're ready to roll, and received hundreds of questionnaires from inside and outside prison. So we're moving as fast as we can. I know we're not faster than the virus. It's already in the prisons, and that's causing anxiety. We get that. I will say one other thing. Some people are submitting things that don't necessarily make them great candidates for release under COVID, because the court may decide that if you're younger and you're healthier, and we are receiving some applications from people who are understandably are just worried because they see people on the outside who seem young and healthy, who have been crippled by this disease. And we totally appreciate that. But it is okay anyway, because we'll have you now in the database, in the clearinghouse. And even as this thing seems to pass, these are going to be compelling arguments to make to get people out. And this clearinghouse is not going away. So while we're moving as fast as we can, we want you to know that we're gonna submit as many as we can as fast as we can. Let me get to some other questions.
If I can add one more thing, though, you may not hear back from us right away. It is because every time we take the 10 or whatever minutes away from reading a new survey and getting a new person into the system slows everything down. Our priority now is to make sure every single person who has written to us, who's contacted us about this from inside or through our website, that we know about them. We have our eyes on, our hands on those requests, and we put them into the places where they need to be so that we can get out. So right now, you're not going to necessarily hear back from us, but it's because we're working so hard to be sure that everybody is looked at and that we know who we need to get to lawyers as quickly as possible. We'll make a commitment to try and get back to you if we determine that we can't be of help to you at this moment. And hopefully, of course, we'll be able to get a lot of lawyers involved so that they'll be in touch with you as well.
Mary, do court motions get filed with the original sentencing court and go back before the same judge if the judge is still on the bench?
Absolutely. That's how it's done. It's a reduction in sentence motion. So it is the court that originally sentenced you or sentenced your loved one, and that's who will consider. Now, it may not be the same judge if they're no longer on the bench, but that's who it goes back to.
I want to add something there. The BOP is not the one who decides if your sentence should be reduced, which is different from home confinement, where the BOP makes a decision. For compassionate release in the federal system, you have to make the request to the warden to start the process, to start the clock, because sometimes the warden says yes, and then the BOP can bring the motion on your behalf. If that doesn't happen, that's when an attorney files the motion in court. This confuses a lot of people because you have to ask the BOP first, but the BOP is not the ultimate decider. It is your sentencing judge that is the ultimate decider of whether your sentence should be reduced.
Good point. Does having a lawyer over pro se move you to the front of the line in courts?
No, not necessarily. I don't know how, Julianne, you may know more about this, but how courts sort of line those things up. I think pro se petitions tend to go to a pro se clerk initially. Is that right? What's your experience?
I'm not sure what the question means by front of the line.
Better treatment, I assume.
Sorry?
I mean, I would think better treatment or quicker attention.
So I think all judges handle their dockets differently. Courts, I know courts take pro se petitions very seriously. They may go to a different place at first, but generally motions are handled in the order they come in. That said, lawyers are trained in a specific language that can make arguments very clearly. And so it may be that an argument is understood differently by a lawyer than by a pro se applicant. That's not always the case, but that's a possibility. And federal court is a complicated place, and that's why we really want to get as many lawyers involved as possible. People certainly have the right to proceed pro se as well, and we can't give advice about whether or not that's the best choice.
If
Can I add
okay.
one thing, which is that if you're proceeding pro se in the court will nonetheless often permit the U.S. attorney to respond to the compassionate release motion, and they've been traditionally opposing them, and then you may or may not get a chance to reply to that opposition, but their arguments are along the lines of, this person doesn't qualify, or this prisoner didn't exhaust their administrative remedies, or the BOP is taking care of this, so you really don't need to let this person out because everything's fine. All of those things need to be answered and dealt with, and it would be most useful if you're able to do that with counsel.
Okay, if I applied for home confinement for the same reasons instead of compassionate release, does this make a difference? Would it be best to resubmit and specifically ask for compassionate release? If you look at the bar memo about who they are considering for home confinement, you're going to see a lot of overlap, I think, with the sort of the categories that are going to be the best fit for compassionate release. My suggestion would be to apply for both, but just be aware that those are two separate processes, and that the BOP is going to make all the determinations about who gets home confinement, and then compassionate release is the process we're laying out here today. So I do think everyone who is applying for compassionate release should also ask for home confinement. The Attorney General, the Justice Department is telling folks that they are granting hundreds of new home confinement requests. We haven't heard about them, but that is what they have said they're doing. And maybe as the crisis gets more dire, they will do that. So I think asking for home confinement is a no-brainer, and compassionate release just requires more justification. But I think if you are somebody who's in a vulnerable category, both of those are good avenues to pursue.
Can I add something about home confinement versus compassionate release? There's categories of who can apply for home confinement that are based on category of crime and distinctions around violent and nonviolent. That is not true for compassionate release.
That's a good point. Mm-hmm.
There are no offense bars to applying. So there is no one with any category of crime that is not allowed to apply for compassionate release. But I do want to emphasize that the categories, you can read about this on our website, the categories are if you have a terminal illness, if you are debilitated, if you are elderly and have medical conditions. There's a list, and then coupled with the COVID CDC vulnerabilities. So if you're over 65, if you have a pre-existing condition. So those are the categories that judges look at for compassionate release, but people with violent crimes can apply, and we have seen them granted on many occasions, as well as people with other kinds of crimes.
That's a really important distinction, that home confinement in this administration is almost certainly not going to be granted to people who have anything but low-level nonviolent offenses, based on the Attorney General's directive. I want to ask, somebody asked about if they submitted their application but failed to include something in the questionnaire, information that might have been helpful, but that they now have, what can they do? Juliana, you're doing intake. How is that going to work?
So again, I want to, they mean not in their request to the warden, but in their questionnaire to us.
That's what I assumed, because it says questionnaire. Mm-hmm.
So again, I want to stress again, there's two different things. You still have to make the request to the warden, and then they also get the information to us. They're welcome to update that. They can send an email to fam@fam.org, and it will get to me, to our main email address, and just include the name of your loved one, and I'll include it in the records. You can also fill out the survey again online with a complete set of information.
Okay, we're getting confusion about the difference between our survey and the request to the warden. And what they don't know is how do they submit to the warden? What is the form that somebody uses?
Yeah,
Let's talk
that's
about that a little bit.
So within the facility, so I'm going to talk first about if the person in prison is submitting the request. It varies by facility, which is not very helpful. Some facilities it's a BP8, some facilities they have a specific paper form, and we recommend talking to your counselor. That's gotten increasingly difficult in a lockdown situation. And so if your loved one is submitting for you, there is no form. There is no form to find. It is a letter or email to the warden requesting compassionate release, including the name and register number of the person, why you are requesting it. It doesn't have to be legalese. The wardens aren't lawyers. It's set up to be a process that the person in prison or their loved one can do. So name and register number, why you are requesting release, and your release plan. And it's important to know when you submitted it. So to keep a copy of the email or the letter, if you're sending a letter, if it's possible to send by certified mail so that you have a date, all of those things are important.
I'm just going to repeat this and just hammer it again, because the first email we sent in to the folks in prison was to tell them, put the request into the institution. That's what starts the clock running. So before we even started getting our lawyers lined up, we asked for that to happen. And if you haven't done that or your loved one hasn't done that, do that now. And as Juliana said, there's forms that are in the institutions. Usually it's a BP8 form, but it can be a scrap of paper that your loved one gives to the counselor and says, I request compassionate release or reduction in sentence. Just something that can memorialize the request. If you send it from home, same thing. And as she said, it can be a letter, an email. If you phone call, document it, whatever you can do to make clear that you've made the request of the institution, we need to do that. Go ahead, Juliana.
I was saying the reason, I think I was saying what you were going to say, which is the reason we do that is if otherwise you file a motion with the judge will say, I can't look at this. You didn't request first to the warden. And so that's why that step is so crucial.
Okay, so that is the step that has to happen. And then the second step is helping us understand the case better so we can try to match you with an attorney to represent your loved one. But so those are two different things. I hope that's clear. If you have any questions, let us know. But people are asking about what the form is, and it's different in different institutions, as Juliana said. Usually where I was, it was a BP8 or BP9 form that you submitted to your counselor in a lockdown. I understand that's going to be harder, although I think people are able to get out, at least for some period of the day. And they should talk to them and let you know if they were able to do it. If they weren't, as Juliana said, send a letter, send an email to the prison, and just memorialize the request. And don't worry about how much you say. Make sure to clear their name, their register number, and just basically why you're asking. It can be elderly, pre-existing conditions, plus COVID, whatever you want to say.
Can I add two things?
Can I?
Oh, sorry. One, I want to say there's a lot of, because of lockdowns, there's a lot of strangeness happening. We want to know if you're getting refusals to accept. I also want to say the people that are stuck in Oklahoma FTC, which is the transit center, but because there's a moratorium on transit, people are just staying there. The government has said that there is a way to submit even at Oklahoma FTC. If you're getting other information, I especially want to hear from it, but to make the request any way you can, because the government has represented in court that even at Oklahoma, which is, there's, even if it's not your permanent facility, that you should be able to apply there.
Can I add just a couple of things? That's excellent. The other thing I would say is if you're in touch with your loved one and the request is based on medical, which frequently it is, have your loved one request their medical records from the institution. You don't have to get all of their medical records. Smaller requests, more time-limited requests are better. But it's better to begin that process so that if we are able to match you with a lawyer, they may get your records sooner and are able to argue from your medical situation to make the arguments in this period of time. That's one thing. And the second thing is, if by any chance you already have a lawyer working on compassionate release or are on the case, do let us know. We've had a couple of situations where we've gone far down the road and gotten lawyers and gotten them all up and running, only to learn that the person already had a lawyer. So don't forget to tell us that part. If your lawyer is working on compassionate release, we want to know about it. But we may assume that that's going forward okay. So thanks.
Somebody asked, do you know when they'll make a decision on who qualifies for home confinement? I really don't want to talk much more about home confinement because that's separate than compassionate release, and I fear that we will confuse people. All we can tell you is what the Attorney General put out there. He has the authority right now to give more people greater periods of home confinement. In his directive, they have listed the criteria that they're going to use to judge that. It is mostly elderly, nonviolent people who they consider low risk based on the risk assessment tool that they have. We do not know how they're going to do that. And we have heard from many of you that different institutions are addressing this differently. Some think that the BOP is going to select those they think fit the categories. In other cases, they're putting it on the person in prison to request it. If you think your loved one is at all a fit for what the Attorney General laid out as the criteria, I would request it. But that there's nothing we can do about that. They're not pre-selected. We don't know the timing. If we had our druthers, they would be emptying the halfway houses and the camps and all low-risk people yesterday. So I have no guidance on how the timing is going to go on there. It's already late. So I just want to say that home confinement is definitely different. Nothing that we can really give you advice except to say, look at our webpage if you're looking for the criteria they're using. But if your loved one is anywhere remotely connected to those criteria, I would ask for it.
Can I add a couple things for people who are joining us late? We're talking about federal compassionate release. It's not because we don't care about states, but because the authority is different. And this is one initiative we're doing, although not the only one. This only applies to people who are serving federal sentences. There are state mechanisms for compassionate release, and you can learn more about that on our website. The clearinghouse is only for federal. Relatedly, compassionate release is only for people who are serving federal sentences. If they have not been sentenced, compassionate release is not the mechanism for them. If they have not been sentenced, they should have an attorney, and you should speak with the attorney about concerns about COVID and placement, etc. I also want to say that people who are non-citizens can apply for compassionate release, and I want to make sure that people know that. There's additional, layers, but it's not confined to citizen clients, and that's an important thing as well.
Somebody asked about, can you file for clemency and compassionate release at the same time? Absolutely. Just know that clemency is a much longer process. I think most people have the feeling that if the president is going to make a grant of clemency, it's been proposed to him by others, advocates, as well as ourselves, that he do so as a categorical measure, that he look for people who fit a certain category and do that instead of trying to whittle through individual cases. I don't know if that's likely. But so applying for clemency as an individual, there's no downside to it. I don't think the Office of Pardon Attorney is going to get through these petitions in a timely fashion. The benefit of compassionate release, again, and this is what distinguishes it from the state mechanisms, is that a clock runs, and then after 30 days, you can go before a judge. In a lot of the state systems, which we can address at the 2 o'clock call, please keep in mind that this is just federal compassionate release. At 2 o'clock, we're going to do a call about state advocacy and other federal issues if you want to talk about those. This is just federal compassionate release. We can talk again about the states at 2 o'clock. In the request to the warden, if the words compassionate release or reduction in sentence are not in the letter, but the words release to home confinement are in the letter, is that satisfactory? If not, should the letter be rewritten and submitted? I would think yes, that's not a request. If you're requesting home confinement, that's a different request than requesting compassionate release. Is that right, Mary?
Absolutely.
So you can consider that letter to have been a request for home confinement, nothing wrong with that. But if you want to request compassionate release, submit it using those words, reduction in sentence or compassionate release, and at least setting forth the reasons why the person is justified because they're vulnerable at this moment. How do you find the warden's email to send a letter about compassionate release?
if you go to the BOP inmate, if you go to the BOP inmate locator and you look up your loved one, you can then look at the institution where they are, and there is an email address. Generally, it is, something at executive assistant .bop.gov or whatever. I don't have it in front of me, but that's the email that you would use. And of course, you can also use the snail mail. I think Kevin or Juliana recommended also sending it by certified letter. But to get it started, of course, you can email. You can email a PDF or a scan of your letter, and then also mail it as a snail mail letter if you can.
Somebody said, won't the Office of Pardon Attorney administratively close your commutation petition if you have pending litigation, e.g. a motion for compassionate release? I'm not sure the answer to that. And
yeah, I think that may be the case. I don't know. You probably have to visit the Office of the Pardon Attorney website. I'm sorry, I'm saying I don't know, I guess. But there is an Office of Pardon Attorney website, and they might be able to answer that question there.
Okay. I don't know if there's any other questions. We're almost at the end of time. I just want to repeat a couple things. We're going to post this on our site, so you can watch this later if you missed it. And of course, if you missed it, then you don't know I'm telling you this. But also go to our COVID resources page, because there's going to be a lot of information there. It's really walks you through how to apply for compassionate release, what you have to do, the notification to the institution, and then as well as the question in there that we're asking for. Repeating again that those are two separate things. I know there's a lot of angst, and people are saying, I want to know if I'm going to have an attorney. Again, we're under 2 weeks from start to where we are now. We did the training last night, which will be live, and we expect attorneys to be well briefed now on how to carry this out. As Mary said, they're really excited to help in this effort. So I think there's going to be a lot of competent attorneys that are going to put your loved one in the best position. So give us a little time, I would say another few days to a week, to start hearing from people. And hopefully you'll start hearing more from the attorneys that they're taking on your case. And we're going to try to figure out a mechanism that we can respond to those who haven't heard. But again, it's just the same team we've had doing this, except now we have several hundred requests at once. I know that's not of solace to you because this is a stressful time, and we get that. So if you do pursue other avenues, that is totally fine. Let us know. We're just doing what we can because we think this is such an emergency situation. As we've said from the beginning, the reason we're pursuing compassionate release at the federal level in this way is that these people should not have been in prison anyway, by our lights. These are the people who are the least dangerous, lowest risk of reoffending, the costliest to house and to care for. And there's just no threat to public safety. So we've been working on this issue for years because we didn't think these people needed to be there anyway. Now we have a virus spreading throughout this country that threatens these same people, puts them at most at risk. And so the federal system, thanks to the First Step Act, has a mechanism to get these people out of the political system and before judges. So while this is not everything, it's the best we can do in these circumstances. We won't get everybody taken care of, but we're just doing our piece to try to make this happen. When we talk at 2 o'clock, I think I'm going to have my friend Udi from the ACLU join us. They're going to talk about litigation at the state level, executive orders that that governors are starting to finally issue to get people out of prison. It's finally catching on that people need to take action. There's some states, yesterday Governor DeSantis said he's not going to release people from prison. There's been some discouraging steps. We're doing this piece because it's something that we know best and that we think that there's a chance to help some people. It's not going to help everybody. What if the warden will not let the inmates submit the release without medical, and the medical people are not giving out records?
Again, I would document that situation, that you your loved one attempted to ask for compassionate release, attempted to ask for the records. You can go ahead and write to the warden on their behalf. And we want to know about those situations because we're going to make a fuss.
Yeah, I would just say in the normal course, if this were just a normal process, not during this period, that kind of thing might mean more than it would now. I mean, our view is that we're going to the courts with as much information as we have, you know, with whatever evidence we have that notice was made, and we're going to ask them to act in this emergency situation. But do everything you can in terms of documenting, as Mary said. But you know, not every I is going to be dotted and T crossed in this circumstance, especially with the lockdown.
Can I? Oh, are there more questions?
No, go ahead.
Oh, I was just going to add that the three of us are not doing this on our own. I mean, it's a big job, but we have remarkable partners in the Compassionate Release Clearinghouse, and they include the Washington Council of Lawyers, which has raised hundreds of attorneys on our behalf and is part of this process. The National Association of Criminal Defense Lawyers, who also has found over 100 attorneys and are partnering in remarkable ways, including setting up our entire database system and coordinating all the systems for training and so forth. And especially the federal public and community defenders. They're not necessarily a part of the clearinghouse, but we collaborate with them on a daily, sometimes an hourly basis. And they are winning some remarkable cases right now. We are sharing resources. We're relying on each other for information. And what this means is that we're building we are together building this remarkable network of support that will amplify the work that FAM does in this area and others. Yeah, that's all I want to say. I think.
If you have questions, because you know we have a little more time, but if you have questions that didn't get answered, or if you're somebody who's watching this later after we've posted it, just add your questions as a comment under the video, and one of us from FAM staff will get in there and answer questions tonight and tomorrow so that we can be as responsive as possible. If there's no more questions now, I think we'll finish. I just want to say, if you have friends who you know think would benefit from joining our closed Facebook group of affected family members or formerly incarcerated, please have that. I think that is an important way for people to share information with one another, find out what different institutions are doing. In some cases, allay some fears about what's going on. We know that people are worried about the information they're getting. We also see that the numbers are rising from BOP in their daily reporting on their dashboard about how many people have been infected. This is no surprise. We knew this was gonna happen. It's why we wanted them to take action sooner. But you know, join the group, follow us on Facebook or Twitter, any way you can. Again, go to our resources page. When you go to fam.org, there'll be a pop-up box that tells you how to find our COVID resources. Lots of ways that you can take action. Make sure your lawmakers know that you're concerned about this. And then, of course, information about compassionate release. So with that, I think we will sign off, and thank you for participating. And again, post questions afterwards when you're done. And thanks and good luck to everybody. Stay safe.
Bye, everybody.